Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series talking about the federal and Florida M&A Broker Exemption. Following the SEC's lead, effective July 1, 2016, Florida passed a statutory exemption from the broker-dealer registration requirements for individuals and entities affecting securities transactions in connection with the sale of equity control of private operating businesses, called an M&A broker. In this Lawcast series, I've gone through the specifics of the new Florida exemption. In this and the next Lawcast in this series, I will discuss the federal exemption. On January 31, 2014, the SEC Division of Trading and Markets issued a no-action letter in favor of entities affecting securities transactions in connection with the sale of equity control of private operating businesses. The SEC stated that it would not require broker-dealer registration for M&A brokers arranging for the sale of privately held businesses in accordance with the facts and circumstances set forth in the no-action letter. The no-action letter does not cover the facilitation of sales, mergers, or acquisitions of publicly reporting, operating, or shell companies, which activities still require broker-dealer registration. The SEC defined M&A broker as a person engaged in the business of effecting securities transactions solely in connection with the transfer of ownership and control of a privately held company through the purchase, sale, exchange, issuance, repurchase, or redemption of, or a business combination involving securities or assets of the company to a buyer that will actively operate the company or the business conducted with the assets of the company. The buyer would not have to be involved in daily operations, but could actively operate the company through the power to elect executive officers and approve the annual budget or by service as an executive. The SEC defined privately held company as a company that does not have any class of securities registered or required to be registered with the SEC under Section 12 of the Exchange Act, or with respect to which the company files or is required to file periodic information, documents, or reports under Section 15D of the Exchange Act. The SEC specifically states that the no-action letter does not cover shell companies. The SEC no-action letter provides an exemption for M&A brokers that facilitates mergers, acquisitions, business sales, and business combinations between sellers or buyers of privately held companies. M&A brokers may advertise the sale of businesses, including descriptions of the business, location, and price range. In the next and last Lawcast in this series, I will go through the limitations to the federal M&A broker exemption. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.